Hi, my name is Dave Dinkel, and today we're starting a series called Legal Mythbusters for both real estate investors and realtors. The topic today is going to be land trust. What's the real story? Fact or fiction uncovered? First of all, this disclaimer, I'm not going to go through it, but when you get a chance, read it. It's important. One of the more important parts, frankly, is this applies to the state of Florida only. The participants are myself as interviewer. There's where you can contact me. I'm interviewing Ryan Shrouder as our guest speaker, Sphinx, Shrouder, and Carnes, PA. What is a land trust? Ryan, tell us.
Thanks for having me, Dave. A land trust is a unique designation or a specific type of trust. Traditionally, you had trusts such as revocable trust or irrevocable trust, which you could hold property in, usually in conjunction with some type of estate planning. But a land trust takes that a step further. It's a trust that's designed specifically to hold real estate. Like any trust, it's disregarded or pass-through entity, so the actual legal title is held in the name of the trustee, not necessarily an LLC or corporation. A land trust is a special trust that allows you to hold real property in it, and it makes it easier for beneficiaries and trustees to actually transact business because the statutes are written to be more real estate investor friendly.
What is the real purpose of a land trust?
The two biggest benefits to a land trust is that you can buy property, and one, the owners, the true beneficiaries, can have anonymity or be anonymous. The actual ownership isn't reflected or recorded anywhere in the public records. The only thing that would be recorded would be the name of the trustee. So anonymity or being anonymous is one of the biggest benefits of it. A second one is limiting liability or asset protection because the beneficiary's exposure or risk of loss would be limited to its ownership in that trust. So say you wanted to have a rental property owned by a land trust, you're renting it out, something happens to one of your guests, they file suit, they're not going to be able to go after the beneficiary's other assets, other properties that beneficiary owns outside of that trust. So that's really one of the biggest, and for our purposes, second reasons why you want to do it. And then the third reason is the ability to transfer and transact business easier. And that could be in the situation of a probate, where if you own the property individually, you might have to probate it. Instead, when you own it in a land trust, it would pass based off of whatever those rules are you have there outside of probate. Or if you wanted to just treat that ownership of that trust as personal property and just sell it with a bill of sale or exchange it in some way other than doing a closing and having to do another deed and transfer it that way. So those are the three big reasons to do it: anonymity, asset protection, and ease of transfer.
For any of you who are curious about where can you see the biggest use of land trust, next time you go to Disney World, those were accumulated by land trust purchases so that no one knew who the actual buyer was. Walt got those properties at a bargain basement. Had they known Walt was coming, would have paid a whole lot more. Why use a land trust instead of an LLC or a corporation?
There's several different benefits to use of anything, but I'll really emphasize a land trust is a disregarded entity. So for tax purposes, you would look past the trust and go right to the beneficial owners. An LLC, you could do the same thing. You could be taxed as a sole proprietor or as an S Corp. But the difference is with an LLC or even a corporation, you have to register those with the state and re-register them every year. And you usually don't have as much anonymity with those, or at least if they're registered in like the state of Florida. There are some states like Delaware or Nevada that will show you less information online regarding who operates that corporation or LLC. With a land trust, you don't have to go and incorporate it anywhere. You don't have to go to the state and file anything with the Secretary of State, and you don't have to pay yearly fees to renew this.
Are they really legal?
Absolutely. Obviously, laws differ in every jurisdiction, but every jurisdiction has some type of trust that you're able to hold legal title into. In Florida specifically, we have the Florida legislature passed the Florida Land Trust Act back in 2013. So not only is it legal, it was codified with an actual statute, 689.071, and the legislature set out not only that it was legal, but what you can do with it. They kind of help codify or put in the law the specific rights and benefits to using a land trust.
Okay, well, what about avoidance of liens, especially super liens? And why don't you tell us for a second what super liens are?
Okay, this is one of the biggest benefits of using a land trust. Super liens are liens such as code violations that become liens that are municipal, city, or their county, or some other type of other government lien. So when you have a super lien or say a government lien for a code violation against you and they record it, it attaches to all property you own. Theoretically, Miami-Dade County had a lien against you and recorded it in the public records of Miami-Dade County. It would attach to all your property in Miami-Dade County, but they could take that and record it in each of the 67 counties in Florida. And that lien would attach to everything. So where that really comes into play with investors is if you're looking to buy a property that's distressed and maybe already has running violations on it and may occur additional running violations, you do not want to purchase that in the name of your main business because those liens are going to then attach to everything else you own. And for that reason, it really behooves you to open a land trust with that specific distressed property. Say you might buy a property at a discounted rate with the hopes of being able to work out the different fines and liens or get them some type of forgiveness. If that goes south on you and you're not able to do it, you don't have to worry about those liens attaching to your other assets. You're limiting your exposure, so to say. You're capping your exposure. And so that is a huge benefit. You don't know how many times people call me up and tell me that they purchased a property and they have some liens on it, but it's only on that property. And why is that affecting the sale of other properties they have? It's a hard pill to swallow to let them know that that attaches to everything.
I once purchased an REO from Chase. When we got to the closing table, one of the super liens popped up for $850 for an elevator mechanics lien. So those things can haunt you. What if the trustee and the beneficiary are one and the same?
Usually with normal trust, you have an issue of mergers, something called the Doctrine of Merger. But with land trust, at least in Florida, the Florida statute specifically excludes or prohibits the Doctrine of Merger being applicable. So in Florida, most land trusts you would have the same. The beneficiary and the owner would be the same, and that's acceptable.
Is there any liability if the trustee is the beneficiary, that it's additional?
It's not that there's additional, but with the way they wrote the statute in Florida, and let me, if you don't mind, take a reference to it. I think it's subsection 5 and that one I gave you earlier, 689.071. So the Doctrine of Merger does not extinguish a land trust or vest the property in the beneficiary or beneficiaries of the land trust, regardless of whether the trustee is the sole beneficiary of the land trust. So what that does is that still allows you to have that limited liability, that separation that you ordinarily would have if the ownership and the controlling interest, the ownership being the beneficiaries, the controlling interest being the trustees, are not identical.
Okay, great. What are the parts of a land trust?
The actual actors or parts of the land trust would be usually have a trustee and then you have beneficiaries. Those are your two biggest parts in the land trust. Oftentimes they're one and the same. Other times they're not. You have the trustee who's a specific person because if you're looking for anonymity, you obviously wouldn't have the beneficiaries named as the trustee. So the trustee would be one and then you can have whoever the beneficiaries are second, the other part of that.
Okay. Only really other part is the document itself, correct?
Technically, two other parts. You're going to have the deed transferring the property into the trust, and then you'd have the written agreement, which would be the trust. It's going to set out basically what are the rules, who the beneficiaries are, and each person's obligations.
Does it make a difference if it's quick-claimed into the trust or it's transferred by a warranty deed?
It does not. If you're purchasing, you want that to be a warranty deed, obviously. If you're selling, you always want it to be a quick-claim deed because there's less warrants you're giving when you give out that property. But no, any type of conveyance in is fine. It doesn't even have to be fee simple ownership. It could be leasehold ownership.
Well, explain that because a lot of the listeners will not understand the difference. They may not even know what fee simple means.
So fee simple basically means absolute ownership, not a life estate, not a partial ownership, not a leasehold, not where you have the right to the property for a certain specific time. So fee simple is absolute, what you would consider owning the property outright. The land trusts allow you to actually put any type of other ownership into it too. So if you just had a leasehold ownership in it or you had a right to lease it, different types of options, any type of interest you could have in real property can be held by a land trust.
Okay, right. Can an entity be the trustee?
Yes, an entity can be the trustee.
Okay. Is there a benefit to that?
That's up to the specific person. A lot of times there is, because the trustee can always be sued for any acts that they do, any issues they have. So if you have an entity as a trustee, you're certainly limiting that. You also have more anonymity. So if you wanted to have a land trust with a trustee being ABC Company out of Delaware, it gives you some more anonymity. You basically, when you look in the public records and say this was recorded in Florida, you wouldn't see the name of an individual. You would simply see LLC, ABC Corporation, a Delaware corporation, as trustee of the 123 Main Street Trust. And then to find out who is the owners of that corporation would be even harder, or the actual individuals, because you didn't have to go to that state, Delaware, or, I mean, theoretically it could be any jurisdiction. It could be Bohemian Corporation or any type of entity or person.
Okay. Does the trust actually have a lifespan?
The trust does. The trust lifespan is dictated by the actual trust agreement. So if you say the lifespan is for 2 years, it would have that. If you say it's in perpetuity, it has that to the extent the law allows. Or if you have some other type of deadline. General rules are, if you have a frustration of purpose with the trust, it could end it. So if you say the purpose of this trust is until Ryan and Dave sail around the world or something, and then we sail around the world, or we're not able to sail around the world, that would end it, because that whatever purpose we set out in there would be frustrated. Absent any type of specific deadline or finality, in Florida, the rule against perpetuities, which I don't expect anyone to look it up, governs the actual lifespan of all trusts, including land trusts, which means it can't be in existence any longer than 360 years. I don't think we're going to have a problem with that.
I was concerned. Typically what I see with land trust is they expire when the property is sold.
Yes, and that's usually the language you have in the actual land trust.
Right.
But in the situation, if you had two properties owned by one land trust, which you could have maybe for certain reasons, it would depend on your specific situation, you wouldn't want that language, or you'd want it to say the last of the two or something to that effect.
Okay. One of the things that I see, and again, the purpose of this is myth busting, and what I see guys do is they pay to have a land trust drafted, and then they start putting multiple properties into it. Obviously, you can do that, but is there a benefit or is there a risk?
Well, if you do that, you lose the benefit of the asset protection. You would still have anonymity and ease of transfer, but you're adding more assets to that trust. So that trust exposure increases by the additional assets. I've seen that with companies, when properties owned by companies or LLCs, because no one wants to go out and open 50 LLCs a year and have to do 50 renewals. But with land trusts, that's very strange to do unless you had a specific reason, because land trusts don't require you to register them. They don't have annual renewal fees. So you could have your perfect land trust drawn up and just duplicate that trust for each property.
Yeah. Okay, let's talk about who gets sued if something happens. Trustee, the land trust, or the beneficiaries?
Well, the simple answer is the land trust. The legal answer is the trustee gets sued on behalf of the land trust. So the actual trustee would be sued as trustee of the land trust. They're not being sued individually most times, unless they had some specific reason why they individually did an act. Yeah, so the simple answer is the land trust gets sued, and the way you sue the land trust is by suing the trustee on behalf of the land trust.
In the public record, so to speak, is it ever going to show up that the trustee was sued?
It will. If you index the trustee's name, so say Dave Dinkel was a trustee of the 123 Main Street Trust, and you wanted to file suit against that 123 Main Street was renting out, there's a housing rental property, the tenant would file suit against Dave Dinkel as trustee of the 123 Land Trust. They wouldn't sue Dave Dinkel individually, and they wouldn't sue the 123 Land Trust individually, because the actual trust is not an entity. It doesn't hold title. The title is actually vested in the name of the trustee on behalf of the trust. So you would come up with the name of that trustee, and that might be why you, back to your first question, why you may want to use an entity as your trustee.
This is a very important one. I get this question probably once a month. Why do some closing agents issue a check to the trustee individually and not to the beneficiaries?
The biggest issue is liability. That somebody come back and say that the closing didn't occur or wasn't proper because the money wasn't paid. With land trusts particularly, this could be an issue because you're able to sell the property if deeded incorrectly with the trustee powers without the escrow or closing agent ever reviewing the trust. So they won't even have an opportunity a lot of times to review the trust where it says the beneficiaries get to make these decisions. So they're always hesitant to give out money to the beneficiaries and not give it to the trustee and kind of pass that obligation along to the trustee to continue on to pay correctly, because they haven't had a chance to review the documents. Or in a lot of cases, they will give it to you, but to the beneficiaries, but they're going to require their name to be specifically listed on the closing statement that as a line item, almost like a payoff.
Yeah, so So that's the way to get around it, so to speak, is to have the beneficiary listed on the closing statement. Because typically what happens is an investor will come to me and say, I have this check that I can't cash because I can't open a bank account for the entity because it's a pass-through. And I typically tell them go back and explain it or let me explain it to the attorney, and he typically issues another check. But that's not the right thing to do, is it?
No, even with my title agency, I don't like to issue them directly to the beneficiary unless I have that on the closing statement. You know, the biggest thing you don't want to happen is someone to come back after the fact. And let me back up. We say the beneficiary. A lot of times we don't know who the beneficiary is because of that anonymity. So basically the trustee saying, hey, pay XYZ, they're the beneficiary. And we're saying we haven't reviewed a document. We don't even know. So we don't want to hand that money out to someone and then be sued by a real beneficiary saying, oh no, it was required this or that. That's where it's usually, listen, we're going to issue in the name of the trustee. Trustee can go do as he pleases. And that's the same reason why you have trouble with the bank. It's not that the bank can't open them. They can, but they just don't want to deal with the liability.
I found out, ironically, after thousands of land trusts, that one investor was able to open a bank account. He went to the IRS, did get a PIN number, a tax ID number, and opened the account. So then he has to do a filing on that account, which he wouldn't have had to do otherwise, but it's okay. There is one other way, which we're not going to mention here. Let's go on to the next one. What ways can the assets of the trust, which are real property, that means real estate, be transferred to another investor?
Two options. You can obviously deed the property over and it's leaving the trust, or you can sell the actual trust, which would then the assets would go along with that. Because what happens is, as a beneficiary, your interest in the trust is what they call personal property, not real property. Like a vehicle would be personal property. So that sale would be done with a bill of sale as opposed to a deed. Same thing if you sold a piece of furniture and you wanted to write up a bill of sale. So you can transfer your ownership by selling your beneficial interest in that land trust, provided the land trust doesn't have some type of requirement not allowing the beneficiary to sell. But for the most part, if you're controlling it, you can do that.
Does the trust or trustee have to pay income taxes?
At the trust level, the land trust is a pass-through. It passes through. It's disregarded. The IRS looks past it, and they look at the end beneficiary. So the income taxes are paid as if you owned it individually. You're not adding a layer like a C corporation where you're paying taxes and then repaying it. They're looking right past that, and they're looking at as if you own that property individually.
What is the price range, do you think? And I know you don't know what other attorneys charge, but some idea, what does it cost to draft a land trust?
Simple common land trust you'll usually see starting probably around $750. That can go as high as $3,000. The hardest thing to do when someone says, how much does it cost for a trust, is it really depends on, well, how many things do you want in the trust? Do you want a 5-page trust or, a 500-page trust? Trusts are a really unique tool, and you can add a lot of things into them. But as you add, you certainly have more work involved. So I would say for a typical land trust, you're going to see between $750 and $3,000, probably on the lower end of that, if it's not involving very many tax issues or too much of a partnership type of situation.
Okay. Do you need an attorney to draft the trust?
Well, I guess you don't need an attorney to draft the trust as much as you don't need a physician to operate on yourself. But I would suggest you do have it, because the way trusts work are, by law, there's certain requirements that must be in the trust and certain procedures that must be done. If you miss one, it's like a will. It doesn't matter if you have the person on the video saying they want to give it to all their property to their new young wife. None of that matters. It's what's in writing. They look past the intent a lot of times. So I would advise you to have your trust drafted by an attorney. And when you want to fund it, when you want to go put properties into it, certainly have someone look over it. Quick story, one of the funniest things you'll see in law is somebody who comes in with a beautifully drafted trust. I mean, it's gorgeous. They hit all the right parts, but they forgot to transfer the property into the trust. So it's useless. It fails because it wasn't, quote, funded under the law.
When do you need to make the actual land trust document?
The land trust document should always be made at the time the agreement or the actual, whatever the situation is. Whenever the trust is going to receive property is when you would need to make it. You don't want to buy the property and then not have the land trust. So at the time of it receiving property, something it's going to be governing, there should be an express written agreement. The bigger question is, when do you need to produce the land trust? Under Florida law, when property is deeded into a land trust, if trustees' powers are included on the deed, and I'll give you a reference to it. Basically, the deed would say from John Smith to Dave Dinkel as trustee of the 123 Main Street Trust. And then it would say with authority and duty to convey, sell, lease, mortgage, or deal with trust property or otherwise exercise the property property. Basically, it gives you, in that deed, when you're vesting into the trustee, it gives the trustee the powers to deal with the property. You don't ever have to produce the land trust. When you go to sell, they don't ever request it because they say, hey, when Dave received this property as trustee, it says he has the powers here to sell, convey, do all these things. So you wouldn't have to ever produce it.
So that says that in the deed to trustee.
The deed the trustee's receiving would have trustee's powers in it. And that's pursuant to section C1, 2, or 3 of that statute. And if when you go to sell the property, if you have trustee's powers included in the original deed, you'll never have to produce the actual land trust to the closing agent when you go to sell.
That brings up the next question. Who will see the actual land trust document and when?
So if you deed into the property, if the property is deeded into the trust with the trustee's powers on the deed, no one will ever see. The closing agent will never need to see the land trust documents. I don't want to say no one will ever see because there are times, say you were holding your homestead with a land trust and you try to go to homestead exemption, the county will say, hey, we want to make sure that you're the beneficiary and you'd have to show them the document. But for the purposes of investors and buying and selling real property, if the initial deed acquiring the property has trust powers in it, you'll never need to show or produce that trust document to the closing agent to sell it.
Okay, what happens if the trustee goes rogue and does things that are not in the best interest of the beneficiaries?
The trustee owes a fiduciary duty to the beneficiaries. Just like an ordinary trust, you would be able to go after the trustee for anything they did. You can also, if they're going rogue before they went rogue, you can remove them as trustee and appoint a different trustee. So you would either, one, remove them, or if it's after the fact, you would go after them for personal liability.
Are land trusts viable in every state?
Land trusts are viable in most states or many states, certainly in the state of Florida. So like I said, Florida, for example, they cut out a special exception and made this special land trust. A lot of states have followed and done the same thing. In any state, you can hold land in the name of a trust, something similar.
Does a land trust reduce the liability of the beneficiaries since the actual property owner is the land trust?
Yes, the beneficiary's liability would be capped at their ownership in that trust. If the land trust rental property, again, Dave's Rentals was owned by land trust and he's got the big diving board with the backflips and something happens to him and they go to sue, maybe injure themselves for millions of dollars and the property's only worth $200,000, the beneficiary can't lose more than their ownership in that trust. So that would be their maximum exposure.
Which is not the case of corporations or LLCs.
Absolutely. I mean, if you had separate, very small, separate ones, yeah, that would, I guess you could happen, but it's not very practical to open 100 LLCs.
If the land trust trustee sells the property, can the trust stay in place with the same or a new trustee?
That's a complicated question. If that is the only asset of the trust and the only purpose of the trust, and the trust no longer has any assets, it would theoretically fail. But you could open another one very similar with the same documents. Now, if you retained assets in the trust, then it would still be able to remain alive, I guess. And that goes back to your first question, when does it end? If you had in your trust documents that the trust ends at the sale of the property, well then no, they would need to create another trust theoretically.
Okay, so let's use an example here. Let's say that you have 123 Main Street in the trust. Someone comes along and says, I want to be anonymous in the public record. I want to buy the trust. So you would prepare a bill of sale, sell him the trust. Now that he's the new beneficiary, he would elect a new trustee typically, correct?
Yes, in that situation, you'd usually do a bill of sale, an assignment of equitable interest, an appointment of trustee, and a resignation of the other trustee.
Yeah, okay. All right, good. I think we beat land trust to pieces today. There's one final reminder here, and what I need you to think about, you guys that are watching, is whenever an attorney talks about a specific situation, it may be totally dissimilar to what you're thinking of. Everyone wants to kind of fit their situation or their special issue into what a generalized theory is, I'm going to say. So always seek the advice of a competent attorney armed with the complete facts if you're going to go after and look for things like this. We have a number of these coming up, and I hope we myth busted some of these thoughts about land trust today. Very oftentimes, I call them urban legends. An investor will tell another investor, and it's like telling a child that gets around the other side of the room, and it's another story. One of the things we're going to tackle coming up is 10-day right of redemption in foreclosure sales. And I've always been told that it was a 10-day right of redemption, and that's in fact not true. So we're going to talk about that in an upcoming one, correct?
Yes. Dave, I want to add two other things. One of the benefits of the land trust is when you want to insure the property, if you're trying to insure a property that's owned by an LLC, a lot of times the actual property insurance is more money. It's not a bright line rule that if it's held in the name of a land trust, it's going to be less. A lot of times it is. And then just a little towards your final reminder, as everyone knows, the law is very variable specific, or variables really change situations within the law. So we're basically giving you guys some general advice here, but your variables or the variables of your specific situation really can change. If you have a question, reach out or contact your attorney.